Hey, welcome everybody. Welcome to today's episode of the Law of Self-Defense show. I am, of course, attorney Andrew Branca for Law of Self-Defense. Thank you. Thank you. That's completely unnecessary. Thank you. So glad all of you are here. We have a very unusual case to talk about today, and that is a case of what appears to me to be the political prosecution of a prosecutor. Doesn't happen very often. We see plenty of politically motivated prosecutions in our space, dating all the way back to George Zimmerman, Rittenhouse. Many of these cases, especially when cases have some energizing political force behind them, typically racially energized cases. One of those, of course, a highly racially energized case was that of Ahmaud Arbery down in Georgia a couple of years ago. And the first prosecutor on that case was a woman called Jackie Johnson, and she very quickly, immediately realized she had a conflict in the case, and she referred the case out of her office to a different district attorney's office, different county, as you're supposed to do when there's a conflict. Now she finds herself being prosecuted on felony charges good for 5 years in prison, largely because of her decision to do that. So we're going to step through this case and explore how can it be that a district attorney herself is now being charged and arraigned shortly this week, I believe, on these a felony and a misdemeanor charge. And frankly, we'll step through the claims of the state, the claims of the defense, and when you see how little evidence there is, really none at all, to support these charges against her, it's hard to come to any conclusion other than this is a continuation of the racial political maelstrom that has surrounded the Ahmaud Arbery case since the video was released about 10 weeks after the shooting of Arbery himself. So we have some interesting documents here. We have a motion from the defense to dismiss one of the two charges against her. They plan to seek dismissal of the other charge at a later date. Then we have a response by the state, and we'll step through all of those. I think we'll actually do the state response first, because that's their strongest argument for why these, what do they have to offer to the court to argue that these charges should not be dismissed? They must have something, right? So let's hear what that is. And then we'll look at the defense motion to dismiss, which comes before the state response, of course, but how much more substantive that is. I think doing them in the reverse order will be most compelling. As always, folks, of course, we do have a sponsor of today's show, and that sponsor is none other than Law of Self-Defense itself. Remember, folks, you can get a copy of our best-selling book, The Law of Self-Defense Principles. You can get it on Amazon, but don't do that. Go to Amazon, look at the reviews. We have over, I think, 1,200 reviews, solid 5-star rated book. But don't buy it there. They'll charge you for the book. I think it's close to $25 plus shipping and handling. We will give you this book, and it's a real book, folks, real softcover book. It's not just some kind of PDF download. We'll give you a copy of this book for free, We do ask that you cover the cost of shipping the book to you, which I think is $8 or $9, shipping and handling, but we'll eat the cost of the book. And to get this, all you have to do is point your browser to lawofselfdefense.com/free book. Only one per customer, please. Only one free one per customer. Lawofselfdefense.com/free book. And with the holiday season coming up, folks, we have another option as well. The beautiful hardcover version of this book. It's really quite lovely, makes a great gift, looks great on the bookshelf. For those of your friends and family, you don't know what to get dad again this year, get them a hardcover copy of the Law of Self-Defense Principles. This one's not free. They're too costly to manufacture, but they are lovely, make beautiful gifts. To get this one, you can get it at lawofselfdefense.com/gethard. I'm sure dad will love that. lawofselfdefense.com/gethard. Okay. And folks, don't forget, whoops. Let's take care of that. Don't forget to, let's see, how we doing for likes? Not great. Not doing great, folks. Let's see. We could be doing better on the likes for sure. Let's see. In terms of questions, as always, we're also, I believe we should be live streaming this over at the Law of Self-Defense website for our members. They get their dedicated video stream. Let me make sure that's working. Becoming a Law of Self-Defense member, folks, is less. Yes, that's working just fine. Hey, guys, a bunch of Law of Self-Defense members in the member-only chat there. Folks, it only costs less than $10 a month to be a Law of Self-Defense member, get access to all our members-only content, as well as to be able to ask questions in the members-only chat, and every one of those questions gets answered. Alternatively, you'll have to do it in, if you want to pose a question, you'll have to do it in super chat form. And it has to be at least $5, folks, to get answered. Now, I think you're crazy doing it in super chat form when you could be doing it for $5 for one question, when you could be doing it at the Law of Self-Defense members page for $10 for a whole month's worth of questions. But that's a decision for you to make. If you would like to become a Law of Self-Defense member, you can do that at lawofselfdefense.com/join. Simple enough. $9.95 a month, I think it is. All right, so let's recount a little bit what happened here in this case. And let me give a quick look over at Rumble. Yep, that's working. Law of Self-Defense is working. Is Twitter working? It is working. All right, so everybody is streaming. We are streaming everywhere. Oh, by the way, folks, I do note that I am currently at, let's see, on YouTube at 44,790 subscribers. So we're 210 away from 45,000 subscribers. If you're not a subscriber on YouTube, folks, it would be great if you could do that. It helps us with that ridiculous algorithm stuff that they do. You know, it doesn't make us money or anything, but it's a nice milestone before hopefully we hit 50,000 and onwards and upwards. So if you're not subscribed, also please hit that like button. All the likes count. We have what? Let me see. About half the people have liked so far. Half of you have not liked. Why are you here if you don't want to hit the like thumbs up button, folks? I don't get it. But hit that like thumbs up on YouTube. It's really, really greatly appreciated. All right, so let's refresh our recollection on the Ahmaud Arbery case. So we had Ahmaud Arbery, a well-known dirtbag and thief. He'd been arrested for it before. He was characterized as jogging through this residential neighborhood, maybe. He had been around a house that was under construction. He'd been seen there. Things had been stolen from the house before. Some of the neighbors in the community saw him running from the home, from the direction of the home, and suspected that he might be the person or one of the people who'd been stealing items from the home. We would later discover video surveillance footage from inside this home with Ahmaud Arbery in the footage, walking around. And it's a point to keep in mind, by the way, folks, that burglary under Georgia law doesn't require you actually steal something, because there was no stolen property found on the person of Ahmaud Arbery. Burglary under Georgia law merely means that you unlawfully entered the premises with the intent of committing a crime. So if you intend to go in and make a theft of opportunity, but you don't see anything worth stealing or that you think you can get away with, you still committed burglary, even if you don't take anything. The burglary is the unlawful entry for the purpose of committing some crime. And if you're wondering if an abandoned house qualifies, it does, folks. Under Georgia law, it's a very broad definition. A tool shed would qualify. It's enough. And of course, the legal question here for the neighbors is not whether or not Ahmaud Arbery had actually taken something or actually committed burglary, but whether he could be reasonably perceived as having committed burglary, which would be a felony under Georgia law. Because if he could be reasonably perceived as committing a felony, then under then existing Georgia citizens arrest law, Ahmaud Arbery was subject to arrest by citizens. who had that reasonable perception that he'd stolen something. So that's apparently what happened here. Three men, Greg McMichael, the son, was it Travis McMichael? And Roddy Bryant, all decided to pursue the fleeing, some would say jogging, fleeing Ahmaud Arbery in the McMichaels in a pickup truck, Travis McMichael armed with a shotgun, the father with a revolver, Roddy Bryant in his own vehicle. And Roddy Bryant was recording the chase on his phone. This is, of course, the infamous video that captures the end of Ahmaud Arbery. So at some point, Ahmaud Arbery is in the middle of the street. You can see the pickup truck with the McMichaels. Travis gets out. He has his shotgun in his hands. Ahmaud Arbery charges Travis. McMichael fights him for control of the shotgun, and Travis McMichael shoots Ahmaud Arbery a couple of times. I forget how many, and kills him. When the police, of course, the McMichaels call the police. When the police get to the scene and they investigate, the consensus of every officer present, especially after they see the video, is that this was an act of lawful self-defense. In fact, they're telling the McMichaels that on the scene. They're not going to be arrested. They shouldn't expect to be arrested. This is, in the eyes of every law enforcement official on the spot, on the scene, having seen the video, that this was a lawful act of self-defense. But of course, the cops don't make the ultimate decision on whether or not to charge someone. Ultimately, that's done by the prosecutor. The local prosecutor, however, the district attorney in the county, a woman named Jackie Johnson, had a problem. And that is that Greg McMichael, Travis's son, had been her lead investigator before he retired. So they knew each other. They had a prior working relationship. And that's enough of a relationship to create a conflict of interest. It would be inappropriate for District Attorney Jackie Johnson to be making charging decisions or non-charging decisions on a case involving the son of someone who she had worked closely with in the past. So she immediately refers out the case to a different district attorney from a different county. So she's no longer involved in the case. In fact, the timing of all of this is really very important. I think I have a little PowerPoint I can pull up here with the kind of the key timestamps of this event. So February 23rd, 2020 is when all this goes down, and Ahmaud Arbery gets shot right about 1 o'clock in the afternoon, a little bit after 1. But for our purposes, we'll call it 1 o'clock. He gets shot after he attacks Travis McMichael and fights Travis for control of the shotgun. Ahmaud Arbery is dead. And the McMichaels call the cops. The cops show up. Now at 2:14 p.m., so about an hour and a quarter later, the cops are on the scene. Greg McMichael decides to call his old boss, the district attorney, Jackie Johnson. He doesn't reach her. He leaves a voicemail. And so at some point after this, DA Johnson learns of this event. And of course, she immediately knows that she's got a conflict. So Johnson calls District Attorney Barnhill from an adjacent county to refer the case out to him. He doesn't answer his phone. But 5:42 p.m., she makes the first effort to refer the case out because of the conflict she has from her prior working relationship. At 6:13 p.m., District Attorney Barnhill calls Johnson back. And they talk for about 22 minutes. And Barnhill agrees, pressed by Johnson, because he's not really interested, but he agrees to take over the case. So at 6:13 p.m. that evening, the same day, February 23rd, 2020, Ahmaud Arbery's killed at 1 p.m. 5.25 hours later, District Attorney Barnhill from an adjacent county with no conflict of interest with the McMichaels agrees to take over the case as district attorney from Johnson. So 6:13 p.m. is the end of any official involvement that Johnson has with this case. 6:13 p.m., February 23rd, 2020, the same day Arbery is killed. That's the end of any official or unofficial attempt to influence this case in any way. And of course, she'd been trying to refer it out for almost an hour prior to that. Apparently, from the first moment she realized she had a conflict, she was trying to refer out the case. as she's supposed to do. She also, although it takes a day or two, she also, as required by state law, calls the state attorney general's office to notify them that she's referred out the case for conflict, because the attorney general's office has its own privileges to take over a case if it wants to, if the original district attorney had a conflict of interest. So that happened 2 or 3 days after the shooting. Of course, by then, actually, Johnson, again, by 6:13 p.m. the same day, she doesn't have anything to do with the case. So now she has been charged with a couple of crimes. I'm going to open up the state's response to the defense motion to dismiss a charge here. Let me see. This looks like the right one. See if I can make this a little bigger, because it describes the crimes charged here. So a Glynn County grand jury returned a true bill of indictment. So they indicted Jackie Johnson with 1 count of violation of oath of public officer in violation of statute 1610(1). We'll take a look at that in a moment. And also, there's a, where's the second charge? Oh, and 1 count of hindering a law enforcement officer, a violation of another statute. So let's take a look at those statutes. The first here is violation of the oath of office. Let's see if I can make this bigger. All right, so Georgia statute 1610(1), violation of oath by a public officer. Any public officer who willfully and intentionally violates the terms of his oath as prescribed by law shall, upon conviction thereof, be punished by imprisonment for not less than 1 nor more than 5 years. So this is a felony good for 5 years, folks, not less than 1. So felonies are 1 year or more of possible sentence. That makes it a felony. So this is what she's accused of: willfully and intentionally violating the terms of their oath of office. So what is their oath of office? Well, let's take a look at that. Oh, I thought I had it pulled up. Oh, I do. Here it is. So what was the oath that she took that the state says she violated? So this is the oath. The district attorney shall take the following oath. Quote, I do swear that I will faithfully and impartially and without fear, favor, or affection discharge my duties as district attorney and will take only my lawful compensation, so help me God, close quote. So the key phrase here that the state seems to be hooked on is affection, because Jackie Johnson, by all appearances, felt affectionate, cared about Greg McMichael, and presumably by extent with whom she had worked. He'd been her lead investigator, and presumably also to Greg's son, Travis McMichael. And in the days following this event, there would be a whole series of phone calls between Jackie Johnson and Greg McMichael, back and forth, talking to each other. She would sometimes call him and apprise him of decisions that had been made by the state attorney general, for example. Importantly, folks, all those communications that purportedly show affection, which she's not supposed to do in the performance of her duties under her oath, that would be the violation of the oath. That would be the 5-year felony. All of these communications of affection were made after she had handed the case over, referred the case to the other district attorney. So they were all made after Jackie Johnson was no longer acting in her official capacity. She had nothing to do with the case. She's allowed to show affection as a human being to someone she cares about. She just can't do it in her role of prosecutor. But she had no role of prosecutor with respect to this case, effective 6:13 p.m., February 23rd, 2020, when District Attorney Barnhill agreed to take the case over from her. So this is those claims by the state, because they make a big deal out of all the phone calls that go back and forth between Johnson and Greg McMichael. They're all irrelevant because she was no longer acting in her official capacity with respect to the case. So if that's the only evidence that the case has, that the state has of a violation of oath of office, they have literally nothing. Nothing that a fair and impartial jury could believe provided a basis for proving her guilty beyond a reasonable doubt of committing the crime of violating her oath of office. Of course, the risk here is, as we all know, this has become a racially energized circus of a case. And the narrative, the public narrative put out there by the media, by people like Benjamin Crump, is that this was simply a racist murder of a young black man jogging through a neighborhood. And of course, who wouldn't want to swing the penalty stick as widely as possible to strike anybody who might have had anything to do with such a horrible racist act? And one of those people, in the view of that narrative, is Jackie Johnson. And the problem, of course, is the concern that under the best of circumstances, folks, if I put you in front of a jury, there's a 10% chance you get convicted, regardless of your innocence. If you throw in racial animus on the part of the jury, or fear on the part of the jury that they must convict, or their jobs or homes or children at school will be endangered, it may as well be an 80% chance of conviction, because it's no longer a trial being judged on the merits of the law and the evidence. It's being done for effectively tribal reasons. So that's the risk here. I don't think the state has anything that shows Jackie Johnson acting with affection in the performance of her duties in that 5.25-hour period, between the 1 p.m. when Ahmaud Arbery got shot to the 6:13 p.m. when she had washed her hands of the case. There's nothing I've seen the state point to that shows her doing anything in violation of her oath of office in that time period. And that's the only time period that matters, because she had no official role in the prosecution after 6:13 p.m. that evening. So that one in particular strikes me as very silly. The state also makes a big deal out of claiming that she committed a crime by referring the case out to District Attorney Barnhill from the adjacent county, instead of instantly calling the Attorney General of the state of Georgia to take over this case. And they point to a statutory provision of Georgia law that holds the following. It's quite a lot of paragraphs here, but the only one that really matters is the first one. This is statute 1518.5. And it requires that when a district attorney's office is disqualified because of interest or relationship to engage in a prosecution, which is what would apply here, the district attorney shall notify the executive director of the prosecuting attorney's council of the state of Georgia of the disqualification. Upon receipt of such notification, the executive director of that council shall request the services and thereafter appoint a district attorney, so a different local district attorney, a solicitor general, or a retired prosecuting attorney, essentially from the attorney general's office. And they're saying, well, she didn't do that. She called Barnhill instead. Well, it doesn't say this is the only thing you can do. It says she's required to make this notification. And she did. It doesn't say when she's required, but she did it in a reasonably timely manner. She did it within a couple of days of the event. When we know the investigation is going to take days or weeks, the prosecutor's office evaluation of whether to charge is going to take weeks or months, as in fact happened. So a couple of days is certainly timely for notification purposes. And none of this guarantees that the attorney general is going to want to take the case. Remember, one of the options here is that the case would be handed over to another district attorney from another county, which is exactly what she did. Johnson handed the case over to DA Barnhill from the adjacent county. So she doesn't appear to have violated any of this either. They're just unhappy that the attorney general of the state of Georgia didn't get given this case because, of course, he's a real politician. He's a state level politician. And in hindsight, now knowing how politically volatile and racially volatile this case was, I'm sure the attorney general of Georgia would have preferred to have first bite at it. Especially since when Barnhill did take over the case, he came to the same conclusion as the police officers who investigated and looked at the video. and concluded that this was lawful self-defense. In fact, he wrote a lengthy memorandum about it and the legal basis for his decision. So now the attorney general has to deal with the idea that, another prosecutor's looked at it and said it looks like a good shoot to him. But of course, that actually doesn't limit the attorney general, the Georgia attorney general's ability to bring a case at all, as we know, because they did. They did. They took over the case. They grabbed some prosecutors from the Atlanta area. They sent them down to Glynn County, and they had the trial of Greg Travis McMichael and of Roddy Bryant. So nothing here has hindered anything, and there's no apparent attempt to hinder anything. Remember, Johnson didn't say to anybody, to Barnhill, don't prosecute this case. There's no evidence of that. She didn't in any way hinder the ability of the attorney general to bring this case. There's no evidence of that, and that attorney general prosecution was carried forward. So there doesn't appear to be anything there. The other claim made here by this state in the second of the two charges against Jackie Johnson by the state of Georgia is this hindering of law enforcement officers. This can be a felony level offense if violence is used or bodily fluids are used, and these laws exist for an obvious reason. But its base level, even the minimus degree of hindering a law enforcement officer can be a misdemeanor offense. So the relevant portion, obviously, Jackie Johnson didn't use violence or bodily fluids here. They certainly can't claim that. But the relevant section of this statute is only that first paragraph. Except as otherwise provided, a person who knowingly and willfully obstructs or hinders any law enforcement officer and of various other officer levels in the lawful discharge of his or her duties shall be guilty of a misdemeanor. The problem is there's literally no evidence that Jackie Johnson did anything. There's no statement from any officer that she hindered their discharge of their duties. None. And the state doesn't point to any in its argument. So the evidence in support of this second charge, albeit it's only a misdemeanor, appears to be nothing. Zero evidence to support this charge. So with that legal framework in context, let's go back and take a look at the state's response. Now, of course, there were two motions here. The defense made a motion to dismiss here one of the two charges. That they made a motion to dismiss the misdemeanor charge, the hindering of a law enforcement officer, the statute we just looked at, and they give all the reasons for that. Specifically, they run through the name of every officer involved, and every one of them says she did nothing to hinder my performance, my duties. In terms of the more serious felony charge, the violation of oath of office, they do intend to also challenge that before they go to trial, or perhaps when they get to trial. It's not like they're pleading guilty to the violation of oath of office, but the motion they filed first was to dismiss the hindering of a law enforcement officer charge. And the state responded to that motion with their own motion in response. And in that, they're going to argue why they think they have grounds to support these charges against Jackie Johnson. So let's take a look at the state's response. We'll do it in the reverse order in which they were presented. Okay, let's see. And I'll note the state's response is 13 substantive pages long. So it's quite a lengthy document. Let's try to keep hit the key points and point out where they seem to be presenting evidence of wrongful conduct by Jackie Johnson, how irrelevant it is given the facts of the case. So on September 2nd, 2022, a Glynn County grand jury returned a true bill of indictment against Jackie Johnson for violation of oath of office and obstruction and hindering a law enforcement officer. The violation of oath of office is the big one. That's the 5-year felony. The obstruction is the misdemeanor. And by the way, the defense seems to have made some spurious defense arguments too. But I mean, you just make every argument you can when you're the defense, of course. But we'll talk about those as well. So they provide some background. February 23rd, 2020, an unarmed. He wasn't unarmed when he was killed. He was fighting for a shotgun. But an unarmed Ahmaud Arbery was shot and killed by Travis McMichael, jogging down the street. Travis's father, Greg McMichael, and family friend, William Roddy Bryan, assisted in the murder by pursuing. The now famous video was released, taken by Roddy on May 5th. So about 10 weeks after the shooting was when the world became aware of that video. The release of the video of Arbery's death immediately drew public scrutiny, so obviously politically and racially energized the case. One of the issues was involved Greg McMichael's law enforcement background as a former DA investigator, and whether he had received beneficial treatment because of his connections to law enforcement. So here we're only going to focus on his relationship with District Attorney Jackie Johnson. In particular, McMichael's recent employment was with the person who would potentially make the charging decision regarding the case, District Attorney Jackie Johnson. As a result, questions arose as to whether Johnson and her assistants should be making any of the decisions regarding Arbery's shooting death. Well, they didn't, because they immediately referred out the case to District Attorney Barnhill from the adjacent county. A factual overview of the weeks after the shooting reveal DA Johnson's initial handling of the case, how the case got to George Barnhill, that's the other district attorney, before Johnson claimed the conflict. No, she referred it out because it was a conflict. That's why, otherwise there'd be no reason for her to refer it out. Barnhill's actions after the case, and Johnson's communications with now convicted murderer Greg McMichael during the investigation. Well, all the communications between Johnson and McMichael after she was no longer involved in the case are legally irrelevant for purposes of violating her oath or hindering anything, because she wasn't involved in the case. Ahmaud Arbery was shot and killed the afternoon of February 23rd, 2020, right about, they don't say here, but it was actually about 1 o'clock in the afternoon. Greg McMichael, the father, not the person who shot Arbery, that was Travis McMichael, his son, but Greg McMichael called his wife. That went unanswered. And he called Jackie Johnson at 2:14 p.m., so about an hour and a quarter after the event. That lasted 39 seconds. We believe it was a voicemail message. So they did not connect, but at some time later, Johnson learned about this event. She learned who the shooter was. She learned she had a conflict with in making charging decisions about this case because of their prior work relationship. So she called the Waycross County attorney George Barnhill at 5:42. He didn't answer. So Johnson kept trying to reach him. Barnhill's son worked in her office. So she called her employee, the son of Barnhill, and saying, hey, I need to get a hold of your dad. Eventually at 6:13 p.m., Barnhill called her back. They spoke for 22 minutes, and Barnhill agreed to review and advise on the case the following afternoon. So he couldn't begin working on it until the next day. Obviously, he has his own workload, but he agreed at 6:13 p.m. to take over the case. That was it for Jackie Johnson. She has no more involvement with this case at all. Now, I will say that ultimately Barnhill would also declare a conflict. I believe it was because his son worked in Johnson's office, and it went to yet another local county district attorney before the state attorney general's office took it over. But in any case, as far as Johnson's concerned, she's done. At 6:13 p.m., the day of the shooting, she's got no official involvement with this case at all. Let's see. On February 24th, Johnson spoke to Arbery lead investigator Tom Jump. Well, it's the next day. She already doesn't have any control over this case, so there's nothing wrong with her talking to anybody about the case. In the afternoon, and without yet having called the Attorney General conflict, Barnhill, the new DA, and the Glynn County Police Department met to review the evidence on the case. So this is Barnhill, the new guy in charge, and the PD are meeting to discuss the case. They're allowed to do that. Johnson's not even involved in that conversation. The video of the shooting was reviewed along with other evidence, and according to the police in the room, the new DA, Barnhill, concluded the shooting was justified, just like all the police had concluded at the scene. At no point during this time did the district attorney, Jackie Johnson, use the lawful conflict procedure outlined in statute 1518-5. We talked about that previously. Notice the phrasing here. At no point during this time. She did within 48 hours. There's no time requirement in the statute. Presumably, it would be reasonably presumed that it would need to be timely. You couldn't wait weeks after you know you have a conflict, or months, but a couple of days when it's not going to matter. I mean, in terms of the legal process, that's timely, folks. There's nothing that says within 24 hours. It doesn't say within 48 hours, and she certainly did it within 72 hours. So there was nothing that impaired or hampered the state's ability to do whatever they wanted to do with this case based on the notice she gave. So Jackie Johnson did use the lawful conflict procedure outlined in the statute. She just didn't do it during this time, meaning the first 24 hours after the event. She was, of course, familiar with the procedure. She'd used it 25 times earlier in her tenure as district attorney, as she used it here, just not within the first 24 hours. I wonder the other 25 times if it was always within the first 24 hours. I bet it wasn't, because if it was, the state would be arguing that here, and they're not. She believed that a conflict existed when the former courthouse employees were witnesses. Well, Johnson always thought there was a conflict. That's why within hours, by early that evening, she had referred the case out to Barnhill. Rather, instead of using the lawful conflict procedure and immediately notifying the Attorney General's office, that's not required by the statute, that it be immediate. Just has to be timely, and even that's inferred. Johnson allowed the new DA, Barnhill, to render a decision on the case. No, she didn't allow him. The case was his. She'd referred out the case, 6:13 p.m. the day of the shooting. It's now Barnhill's case, just as if it had happened in his own county. He's not dependent on Johnson for anything. He's acting on his own authority. So this is bullshit. She didn't allow him to do anything. He rendered a decision using his own professional judgment in the time he thought appropriate. He's an independent actor. Johnson did believe that it was urgent that this be investigated and the decision arrived at in a prompt way, because everyone could see there were going to be racially energized facets to this case. But I think we all agree that nobody thinks this was unimportant, particularly Johnson. If she had acted in a lackadaisical manner, they would have said, well, she didn't care. She was failing in her duties. Let's see. Hours after DA Barnhill had decided the shooting was justified, so now even he's done with the case. He's made his decision. So hours after that, Johnson found time to call Greg McMichael instead of the Attorney General's office. Well, again, those are completely different events. She's allowed to call Greg McMichael. She's not involved in the case. She can talk to him. There's no prohibition on that. And she calls the Attorney General's office within 24 hours of this call, again, in a timely manner. Then they write, and this is just dishonest. The state writes, this all occurs while District Attorney Jackie Johnson is still presiding district attorney over the case. No, she's not. She's not. She's not. Might there have been a piece of paperwork not done yet? Sure, I guess so. But substantive control of the case for all legal purposes is in the hands of DA Barnhill by 6:13 p.m. the day of the shooting. Johnson is not still presiding over this case. Then the state goes through this long table from of all the phone calls between Johnson and McMichaels. They all occur. Johnson calling McMichael. So the first one here is when Greg McMichael tries to call Johnson about an hour after the shooting. That's not answered, that call. And in any case, Johnson didn't make it. Greg McMichael made it. Then all these other calls are calls that are made the day after or afterwards, later than that. Meaning all the other calls are made after Jackie Johnson's no longer involved in the case in any official capacity. Let's see. Meanwhile, several days pass after the shooting. Yeah, it's 2 or 3 days, folks. Pass after the shooting and Barnhill's decision, and Johnson attempts to contact the Attorney General's office on the 26th. So the 26th is 3 days after the shooting. She sends them an email. It goes to the wrong address. I guess she doesn't get a response, so she worries. So the next day, she sends a conflict letter. Well, she gets the right email. So they're, first day, oops, goes to the wrong email. Next day, it goes to the right email. There's no harm done to the prosecution of this case because of this, because there was an unanticipated additional delay from 3 days to 4 days. And really only, let's face it, this is all happening now in the evening of the 23rd when Arbery shot. It would have been 2 business days to 3 business days after the event, business days, right? When people are actually in the office, they're staffed to prepare the letter and all this kind of nonsense. Also, Johnson had contacted the paralegal in charge of conflicts and told the paralegal that District Attorney Barnhill had already agreed to accept the case. Well, that's fine. That's allowed. You can pursue 2 paths at the same time. She's meeting her obligation to inform the state about the conflict, and she's made arrangements to address the conflict. There's nothing about the statute that says she can't do that. And the arrangements she made is one of the common arrangements that the state itself would make, which is referring the case out of the county to a different district attorney. Johnson failed to disclose to the paralegal that Barnhill had already reviewed the case and declared the case to be self-defense. Listen, she's just notifying the paralegal as the statute requires. She's not required to give a paralegal a detailed breakdown on every facet of the case. It's none of the paralegals' business, frankly. They don't have anything to do with that. They're involved in tracking conflicts, making sure the office is adequately informed. There's a conflict of interest they've been notified of by a local district attorney. That's the paralegal's only job in this context. It's not to be informed that a different district attorney has already declared the case to be self-defense. And here the state is, again, dishonest. Thus, Johnson effectively chose the outcome of the case. No, she didn't. She didn't. She had nothing to do with the outcome of the case. She asked Barnhill to take the case. He did. And he chose the outcome of the case. She had no control over what his decision was going to be. They're peers. She's not his superior. They're peers in different jurisdictions. Let's see. Then there's more phone calls by Johnson. All of these are after she's no longer officially involved in the case. It's unclear what the topic of conversation was in these other phone calls, but circumstantial evidence suggests it involved the appointment of George Barnhill as the prosecutor over the Arbery investigation. Maybe it did. So what? So what? There was nothing wrongful about that. In any case, they don't say the circumstantial evidence here. I mean, what would be the circumstantial evidence? I think they're actually just speculating that they don't have any evidence at all. Let's see. As I say, ultimately, the other DA, Barnhill, would also recuse himself from the case. Now, once the state became aware of the case, they decided to immediately, very quickly, conduct an investigation into Jackie Johnson. Hey, did Jackie Johnson do something wrong here? The Georgia Bureau of Investigation is the state-level FBI for the state of Georgia. So GBI is called in. They do a thorough, weeks-long investigation of the Jackie Johnson's conduct, and they clear her. They say, no, she didn't do anything wrong. Despite getting that result from the GBI, the Attorney General's Office of Georgia says, well, thanks for the investigation, guys, but we're going to charge her anyway. Violation of oath of office, 5-year felony, and hindering an investigation. So now the state's response gets to, they start to state the reasons why the oath of office charge, or rather the hindering charge, should not be dismissed. And their arguments are childish. So here's the first one. The defendant's motion should be dismissed as untimely. Now, the legal process has time windows in which things must be done or you lose the opportunity. And that's just so the system doesn't go insane. So if you lose a case and you want to appeal, generally you have some period of time to do that. If a motion is filed and you want to file a response, you have a period of time to do that. It's to keep the machine working properly. And one of the time windows that could be relevant in a case like this is if you want to challenge a criminal charge, you have to do it within 10 days of the arraignment. The arraignment is when the defendant presents himself in court to a magistrate, typically, and the magistrate says, you've been charged with these criminal offenses. Do you understand the charges? Yes. How do you plead? not guilty. At that point, the defendant's been advised that he's facing criminal jeopardy, and specifically what criminal jeopardy he's facing. So at that point, the state says, the criminal procedure for the state of Georgia says, all right, you've been informed. If you want to challenge these charges immediately for lack of evidence, for example, you have 10 days to do that. If you go longer than 10 days, we're just going to proceed down the criminal justice pipeline. Here, the state is saying, well, the time window for this is 10 days from arraignment, and she's never been arraigned, suggesting that she shouldn't be allowed to challenge for lack of evidence until she's been arraigned and then have a 10-day window. No, folks. It's not that the window starts at arraignment. Arraignment is normally the first time she would know. But in this particular case, she's aware of the indictment and the true bill and the charges in the indictment. So she already was informed. She has up to 10 days after, whenever the state decides to arraign her, to challenge the charges. But the state doesn't get to limit her window to 10 days simply by delaying her arraignment and then saying, oh, now the window opened. Now you have a 10-day window. This is for the benefit of the defendant. It's not for the benefit of the state. So this argument is ridiculous. A defendant's motion to dismiss for lack of evidence should be denied because it has no basis in Georgia law. And this is frankly the way the state phrases this is very misleading. So the legal standard is that the amount of evidence the state has to offer in order to drag you into court is basically anything. A thread of evidence is enough. The idea being that so if a grand jury's returned an indictment, basically the grand jury has said, listen, if we believe only the state's evidence and we pretend we disbelieve all the defense evidence, even though they don't really see the defense evidence, the grand jury. But if we pretend everything the state's saying is true, could a crime have been committed here? And if the answer is true, they return an indictment. That's all a grand jury does. So if the state has even a tiny amount of evidence, well, the grand jury is obliged to believe it's true. And of course, they get the indictment. And if the state does have even the tiniest bit of evidence, then they can argue, well, look, it's up to a jury, not a judge. It's up to a jury to decide the merits of evidence. They're the finder of fact. Now, it may be just a tiny bit of evidence, but the jury gets to decide how much weight and credence they want to give that tiny bit of evidence. It might be 1%. But the jury gets to decide the weight of it. So if we have even 1%, we're entitled to a jury trial, to drag Jackie Johnson into trial on these charges. That part is true. And if there is that 1%, then a hearing court ahead of the trial should not simply dismiss those charges because it's up to the jury to decide. But what if there's not even 1%? What if there's 0% evidence to support the charges? That's a different matter, because if there's 0% evidence, there's nothing for the jury to consider. The jury can only consider the evidence that's presented to them. If there's effectively no evidence to present to them, there's nothing for a jury to do. In fact, the only way you could get to a conviction, the only way you could have something for the jury to do would be if you're trying to get a conviction based on politics, racial animus, and prejudice against the defendant, which I expect is exactly what the state is trying to do here. So here the state is arguing, hey, you're not supposed to dismiss charges. Once we get an indictment, the jury's supposed to hear it. And that's generally true. The difference is there is no evidence. Certainly the state doesn't point to any here. Then they get to the oath. Then this was one of the silly arguments by the defense. They said, hey, when the grand jury returned its indictment, it turns out they were not given the correct oath of service to be on a grand jury. They were given the wrong oath. They took the wrong oath. The Georgia statute has a very specific oath that you have to give to a grand jury. Otherwise, whatever they do is not legally founded. Any indictments returned should be thrown out. But the truth is there's quite a bit of wiggle room in the oath, as the state points out here. So I don't think the defense is going to get anywhere there. I'm not sure what's going on here. They're talking about the court reporter. The court reporter took notes of some evidence and not notes of other evidence. I think the state is trying to say, because the defense says, hey, we looked at all the transcripts from the grand jury proceedings, and there's literally zero evidence in there of Jackie Johnson committing either of these crimes. And the state is arguing, well, yeah, that's true, but our court reporter didn't write down everything. She only wrote down some of the stuff. So the stuff our court reporter didn't write down is the evidence. It's not a very compelling argument for sure. Let's see. Then they get to the remedy of if the state did screw up. I think this would be the let's see. If the state did screw up in some way, they still don't think the charge should be dismissed. Maybe they'd want to go back to try to get another indictment, something along those lines. But nowhere in here is there any evidence to support these charges. Did you see any expressions of affection towards Greg McMichael that were made in the 5.25 hour period that Jackie Johnson had anything to do with this case? No. Any evidence of efforts by Jackie Johnson to hinder law enforcement in the 5.25 hour window that she had anything official to do with this case? No. There's nothing. There's literally nothing in here. Now let's contrast that. Let's contrast that with what the defense had to say, the evidence the defense had to point to when they filed this motion to dismiss. And you'll see how much more compelling and evidence-based the defense motion to dismiss is than the state's response to that motion. Very powerfully written too, by the way. And by the way, for those of you who law self-defense members, I will include the PDFs will be embedded on the blog post for today's show. So you'll be able to access the PDFs. They weren't easy to find. But this one in particular, I encourage you to take a look at. But that's for law self-defense members, folks. Less than $10 a month to be a law self-defense member. You get all this kind of bonus content, about 30 cents a day. And you can get that at lawselfdefense.com/join. Lawselfdefense.com, join. Now, before I jump into, let me take a quick look here and see if there's any super chats that I need to take a look at. Not yet. No super chats. Has everybody become a member? That would be awesome. And let's see, we have what? We have, all right, good. Let's hit the like buttons, folks. We're at about 66% likes up relative to people watching right now. That's great, but we can do better. No reason it can't be 150% likes. So hit that like button. That would be greatly appreciated. All right, so let's take a look now at the defense motion. So they're looking at the to dismiss the second count. That's the hindering of a law enforcement officer, which really on the facts of this case would just be a misdemeanor. They do plan to challenge the other charge as well. But let's look at how this hindering charge looks like that the state has chosen to bring against Jackie Johnson. They go through the facts of the case. Let's see. The police respond. They ask for an investigator. Because the police officers want to discuss the case and conclusions with the prosecutor, former District Attorney Johnson, she lost her run for re-election because of the politics around all this. So she's former DA. But at the time, DA Johnson requested that the adjoining circuits, elected Waycross Judicial Circuit DA, George Barnhill, serve that role, take over the case for the investigating officers. At no time, that's pretty absolute. At no time did former District Attorney Johnson ever utter any direction, order, edict, instruction, request, or any other communication, either directly or indirectly, that Travis McMichael or anyone else involved in the brutal slaying of Mr. Arbery not be taken into custody at any time. Just didn't happen. Did the state have evidence counter to this claim in their response, which they wrote after reading this? No. As we just saw, they had none of this. The defense continues. The allegation in count 2 of the above referenced indictment is a complete and utter fabrication of reality. And as discussed herein, there are no truthful, competent facts whatsoever to support this specious claim. I concur with the defense. So they go over the facts a little bit here. The shooting, we've covered all that as well. They mentioned the, let's see, the GBI investigation, notwithstanding the fact that then serving District Attorney Johnson immediately recused her office from any involvement with this death investigation on the day Mr. Arbery was killed by 5:13 p.m., right? Or 6:13 p.m., 5.25 hours after the shooting. And of course, Johnson would only have been informed, probably 2-3 hours after the shooting. So within an hour or two of her being informed about this shooting and realizing the conflict that existed, she recused herself from the case and handed it over to another DA within an hour or two. So despite Johnson immediately recusing herself from any involvement with this death investigation, the Attorney General of the state of Georgia directed the GBI to conduct an investigation into Johnson's supposed actions. During and after an exhaustive GBI, and by then the feds got involved, FBI investigation, the Attorney General was provided the findings and recorded interviews of the GBI FBI, which completely exonerated DA Johnson of any wrongdoing. So, regardless of the fact that former DA Johnson was cleared of any wrongdoing by GBI and the FBI, just over a year later, after that investigation was closed, on May 24th, 2022, the Georgia Attorney General began a series of sessions with a Glynn County grand jury. They presented improperly sworn evidence, they put evidence in quotes, to the Glynn County grand jury over several months that culminated in the wrongful return of the present indictment. Well, we just looked at the state's response to this, and there was no evidence. So what possibly could the state have been relying on? Well, I think I know. I think I know what they were relying on, because I have a news report here that I've put into Word format, so we don't have to all look at the ads that Google puts all over my web browsers. And this is a news report from the Atlanta Journal, whatever, AJC, I forget the name of the newspaper, just about a week after the video was released, and the video of the shooting of Ahmaud Arbery. And the state attorney general had asked the GBI to probe the handling of the murder case, specifically to investigate Jackie Johnson. And I won't read the whole thing here, but this highlighted part. 2 Glynn County commissioners have told the Atlanta Journal-Constitution that Johnson's office stopped the Glynn County Police Department from making arrests immediately after the shooting. They were told not to make the arrest. Peter Murphy, presumably one of the Glynn County commissioners, said. She shut them down to protect her friend McMichael, Alan Booker said. How would these 2 men know this? Who would have told them this? What's the source of this information? It's hearsay. It's speculation. If there were any factual foundation to these claims, you don't think the state would have included it in the reply to the defense motion to dismiss the charge? If there was any evidence to support these claims, you don't think it would be all over the state's response? It's not there, folks, because it doesn't exist. And this is not mentioned in their response. These claims are not mentioned in their response because they wouldn't be admissible at trial, because they're hearsay. This is just political speculation about what these people imagine might have happened in their heads in the complete absence of evidence. But I think these statements were made. These speculative, manufactured, fabricated claims were made. The state saw them and said, all right, let's run with that. And that might be enough to get a grand jury indictment, because you can show things to the grand jury that you can't show in a trial. So I expect the grand jury was shown these claims and they were like, oh my God, she stopped the police from making an arrest? That sure sounds like hindering to me. So they returned an indictment on that charge. This evidence is almost certainly inadmissible at trial, or the state would have talked about it in their response to the motion to dismiss. So I think that's where the state is coming from with what they think is, that's the evidence in quotes. It wouldn't be admissible because it's inherently unsound evidence, as all hearsay evidence is, unless the hearsay falls into one of the accepted exceptions for hearsay admission as evidence. So let's see, they some more factual background. They talk about the Glenn County Police captain, supervisor of the investigators, looks into the case with other investigators. They viewed the video of the recording of the shooting. He confirmed in his interview with the GBI that none of the Glenn County police officers disagreed with the assessment of self-defense in the killing of Mr. Arbery. So every police officer involved agreed with the conclusion that it was self-defense. They also say the Glenn County police officers were not influenced or pressured by anybody to make an arrest or to not make an arrest in the case. So there was no influence by anybody, much less Johnson. Even on Tuesday, May 19th, almost 3 months after Mr. Arbery's unlawful killing occurred, Captain Jump posited that the death of Mr. Arbery was justified because it was an act of self-defense. Captain Jump also stated that all the Glenn County police officers involved in this case believed that this was a self-defense slaying and thus no arrest needed to occur. So these are the cops acting on their own judgment and investigation. They're not being influenced by Jackie Johnson in arriving at this conclusion. Glenn County Police Department Chief John Powell explained the consensus of his law enforcement officials was that no arrest was needed to be made for the killing of Arbery. Again, because it was apparently self-defense. Interim Chief Jay Wiggins. For some reason, let's see. Yeah, that local police chief, I think Glenn County's got some issues, but that Chief Powell, he was indicted, so a new chief was appointed, an interim chief. He explained, let's see. Right. The former chief explained to the interim chief that this was a pretty open and shut case and that there was no need to call the GBI to investigate the homicide. Open and shut case of self-defense. Let's see. There was no conflict with any of the investigating officers. The interim chief explained that to his knowledge, D.A. Johnson, as well as her office, was recused from the Arbery case and did not participate in any way in this homicide investigation. That's correct. There is not a scintilla of evidence that Johnson ever knowingly and or willfully hindered any law enforcement officer from arresting anyone tied to the murder of Mr. Arbery as alleged by the grand jury. Not a scintilla. That's the 0% evidence, folks, that would justify dismissal of the charge, despite an indictment having been returned. If there was even a scintilla, even 1%, arguably the jury should consider it. They're the finder of fact. If there's 0, there's nothing for the jury to consider. And here the defense is saying there's not a scintilla of evidence. Remember, the state motion we just looked at was a response to this. The state read this sentence. You think if they had a scintilla of evidence, they would not have included it in their response to this document, to this motion? Let's see. It is unconscionable and illegal to permit this hindering charge to survive when all evidence supports no wrongdoing by Johnson, a wholly innocent person. Then they step through a bunch of the other officers involved, and they all have the same findings. It looked like self-defense to them, and they were not at all hindered by Johnson. Here's Officer Red Nobly, Sergeant Stephanie Oliver. I'm not going to go through the details because it's all the same thing in terms of substance. Officer Stephen Lowry, Officer Parker Macy, all of them. They say it looked like self-defense to me, and there was no hindering by DA Johnson. Yep, every single one of these, and look how much. I'm not going to read all these paragraphs, but look, it's multiple paragraphs for each one of these people involved, the people who would have been hindered by Johnson if she had done that. Look how much more substantive this is than the state's evidence-free response to this motion. It's amazing, and it's all specific, detailed, factual attachments, exhibits, sworn testimony. Let's see. Here we get to the those city commissioners who had those quotes in that newspaper article claiming that Johnson had told the police that Johnson had told the police not to make an arrest. So let's look at this. The Atlanta Journal-Constitution published an article on May 8th, 2020. That's what we just looked at a moment ago, where writers Burt Relton and Christian Boone quoted Glynn County Commissioner Dr. James Peter Murphy, as well as Glynn County Commissioner Alan Booker, purportedly stating that former DA Johnson stopped the arrest of Travis McMichael and possibly the other two people involved. Commissioner Murphy specifically denied ever stating that former DA Johnson stopped the arrest of any of Mr. Arbery's assassins. Naturally, the defense motion here has to accept the guilty verdict from the very imperfect trial of the McMichaels. Commissioner Booker's purportedly false hearsay statements made to the Atlanta Journal-Constitution were also unsubstantiated. Moreover, as stated earlier, any and all of these interviews are recorded and can be listened to in open court with this honorable court's permission. Then they get to the point we talked about earlier. In general, Georgia courts do not permit an inquiry into the sufficiency of evidence presented to the grand jury for determination of probable cause. Sufficiency meaning, is there enough evidence to support the indictment? The presumption is that there's any evidence to support the indictment. If there's 1%, that's sufficient to support the indictment. But there has to be 1%, because, however, the general presumption that an indictment was returned on legal evidence may be overcome by showing that there was no competent evidence upon which the charge could lawfully have been returned. As shown herein, armed with grand jury transcripts, it can be proven that there was no competent evidence introduced at the grand jury proceedings that former DA Johnson hindered, obstructed any police officer at any time concerning the death investigation into Arbery. This hindering count, therefore, must be dismissed. Then the defense gets into this supposedly faulty oath that was taken by the grand jury. I wouldn't pay that much attention. So that's it. Pretty compelling evidence-based argument by the defense on why that hindering argument should be released. And given the very, very narrow window, probably 2 hours or so, in which Johnson had any involvement with this case before she recused herself and handed it to Barnhill, there's no evidence of anything within that 2-hour window that indicates a showing of affection, a decision of impartial, favorable treatment of the McMichaels that would be inconsistent with her oath in office, which is the big charge, the violation of oath of office, the 5-year felony charge against her. No evidence of that either. And how really, I mean, it's such a small window. It wouldn't be hard to find if it happened. And remember, the state has to prove these charges beyond a reasonable doubt if it's going to be a conviction based on the legal merit. The risk, of course, is that the state can gin up enough racial animus towards Johnson, given the racial energized nature of this case, that a jury will convict regardless of the legal merit. That's the risk here for Jackie Johnson. It certainly does not seem to me to be any credible foundation for these charges against Johnson, which suggests to me that the only real rationale here for bringing these charges against her and putting her through this process is political. It's simply a political prosecution of a prosecutor. Now, I know some of you in the comments are going to say, well, maybe it's a prosecutor's turn. Certainly the rest of us are subject to these kinds of political prosecutors. And I would only answer, folks, if it's wrong for us, it's wrong for anybody. It's wrong for anybody. Johnson literally did nothing wrong here to be facing a 5-year felony charge and be put through this unbelievably costly and destructive and politically, professionally destructive process, right? She lost her career over it. And she certainly, yeah. I mean, just imagine within a few months, you could be looking at 5 years in prison. How would that affect your life? If there was evidence to support the charges, well, that's what happens when there's evidence to support charges. But when there's none, and as a prosecutor, she'll know if they stick her in front of that jury, it doesn't matter if she's 150% innocent. There's a 10% chance she gets convicted regardless. I think it's wrong when we do that when the system does that to any of us. And it's wrong when the system does it to Jackie Johnson on the apparent facts of this case. All right, so let's take a look at the Law Self-Defense chat, the members chat. Remember, you can become a Law Self-Defense member for only about 30 cents a day, $9.95 a month. Ask me all the questions you want in the members only chat, and I will answer all of them. It looks like mostly we have a bunch of people saying hi. Usual suspects in the members only chat. Good to see all of you. Scott A. writes, wouldn't it be a violation for her to take the case with her conflict? Yes, it would have been a violation of her oath to take it because of the conflict, and that's why she immediately recused herself without making any major decisions in the case, without making any decisions in the case other than the decision to recuse herself. That was from Scott A. Wendy says, presumably she imparted to McMichael information she received in her role as prosecutor. Are they arguing that she was revealing privileged info or at least info that the public didn't yet have? They didn't argue that. And why would she have information? I mean, she's not prosecuting the case. She's not running the investigators. I mean, maybe you think she heard it through the grapevine, but on the facts of this isn't like a drug dealer case where they might kill witnesses if the witnesses are identified. What kind of insider information would there really be on the facts of the Arbery case? Old Bill. This case was the perfect example of somebody who didn't think he needed a lawyer and is spending life in prison because he didn't get one before he talked to the police, who were his personal friends. I'm not sure. They probably knew each other. I'm not sure how friendly they were. Certainly the people leading the investigation. I mean, Greg McMichael had been a cop quite some time ago, but he'd been since then other jobs, and particularly the DA investigator role job. And of course, what really got him was the video. I mean, once the video came out, I mean, he shouldn't have been chatting with the cops. Certainly, I would agree with that. Wendy, I didn't know that about talking to police friends, Bill. Interesting. Yeah, I mean, anything you say to the police can and will be used against you in court, right? So, Old Bill, when Johnson called McMichael and kept him updated on decisions that were made, as you said, was she giving him work product as county prosecutor, and would that act violate her oath? I don't know that she was doing that. There's no evidence that she gave anybody work product. When decisions were made to, like when Barnhill recused himself and another prosecutor was put in charge of the case, she called McMichael to let him know that it happened, but everybody was going to know that it happened. That's public information. Let's see. Wendy, it's an interesting issue, isn't it? Because even though she'd recused herself, if she was still receiving info on the case, she should have stayed silent on it. But we don't know any of that happened, and the state's not claiming that's what happened. So wouldn't the state be telling us that if that was the basis for the charges? No, the state says there was lots of communication, but they don't show any evidence that it had any confidential work product involved in it. These people were friends. They're allowed to communicate. Yeah, Wendy says it's big in attorney circles too. I remember in one of my ethics classes, the instructor saying something like, if you recuse yourself, you're off the case. That means you're off the case. That means you have no involvement further. Yeah, I would agree. I mean, of course, there's official involvement, and then there's things, you might hear chatter by the water cooler. That's not being involved in the case. Maybe there was some of that, but again, the state doesn't claim even that. Old Bill, if the state attorney general is pissed because he didn't get the case, isn't his complaint with Governor Kemp, who gave the case to a Democrat country prosecutor from Cobb County? Yeah, this might just be the state AG trying to get a bite of the pie for himself, and this is the only avenue he figures he can do that through. Wendy, and given how early in the proceedings it was, why couldn't the state attorney general just take the case then? Well, I don't know that they would have taken the case really, but what ended up happening was yet another county prosecutor, DA, was appointed by the governor, which is one of the options in the conflict notification to the state. So obviously the prosecution was fully capable of proceeding because that's what happened. Wendy, if Barnhill had to pass it off also, did he go through the state attorney general office? I don't know. I didn't bother looking into what Barnhill did. He's not being charged, so it's not interesting. Let's see. Yeah, Wendy, I wish I'd paid more attention to the procedure in this case. It's vague. Yeah, I'm not gonna spend several hours going into the detailed procedure of when every lawyer got appointed and recused himself and filed, and that's too much procedure for my taste. Old Bill, Andrew still isn't addressing our question about her communications with the potential defendant violate her oath. How does that violate her oath? First of all, the oath would only apply to her conduct in her official capacity, not to her as a human being. And she was not communicating in her official capacity. She had no official role in the case. So I just don't see how unofficial communications could have any impact on our oath of office. And again, the state's not even claiming that. Where's the state's claim? I mean, they're claiming in a very perfunctory way by bringing the charge, but where's the substance? What exactly? In what exact way did she violate her oath of office? They don't say. Wendy G, is it your typical practice to have, not me, she means the grand jury, to have a court reporter who selectively transcribes proceedings? The whole grand jury process is incredibly biased. So really the grand jury only hears the state side of the argument anyway. The defense doesn't really get to present its narrative to the grand jury. They may be able to impeach some of the state's evidence, but they don't really get to present their own narrative of innocence to the grand jury. So the whole thing is as partial as you could possibly imagine. Let's see, almost at the end. Old Bill, Atlanta Fox 5 reported Arbery's family blamed Johnson for the delay in arresting the McMichaels. Their attorney, Ben Crump, who may be pushing this to give him a stronger argument for another civil suit, he turns these tragedies into cash cows. Yeah, I don't care what the Arbery family is claiming. They don't know anything. They have no insider knowledge. They're just unhappy that their family member got killed, which is understandable enough. Michael says, I know I'm late, but isn't prosecutorial discretion typically almost absolute? Well, this discretion is, but there could have been things that Johnson did wrong that would subject her to penalty. She could have told the cops to not arrest. That could have been hindering. There's just no evidence that any of that happened. So certainly there's things the prosecutor can do that go beyond the bounds of discretion. That could be hindering a law enforcement officer, but there's just no evidence of that here. All right, let me look at the super chats now. Super chats on YouTube. Looks like just a couple. By the state's, Chris D, $10 super chat. Thank you very much. By the state's theory, she wouldn't be able to talk to her child if they were being investigated of a crime. Right. So her child gets accused of a crime, shoplifting, and she recuses herself. She's not allowed to talk to her kid, show affection to her kid. I mean, that would be ridiculous. She's allowed to have unofficial communications outside of her official capacity when she's got no involvement in the case. Let's see. And it looks like there might just be one more super chat. Content of character, $5. Thank you very much. Thinking about political prosecution, what's the status of Kyle's Law? I'm a member, but sometimes YouTube is easier if already on that platform. Yeah, I get that for sure. Folks, I drafted up a Kyle's Law proposal, but I'm not a legislator and I'm not a lobbyist. So I put that out there for people who are legislators and lobbyists to look at and accept or modify as they think best and push it within their own legislative realm. I can't do that. So I don't know what the status is of any such efforts around the country. I wish somebody would pursue it, but it's not going to be me who makes Kyle's Law. Somebody else has to do that. All right, folks. Well, I think that is all I have for all of you today. Remind all of you once more, you can get your free copy of the Law of Self-Defense Principles at lawofselfdefense.com/free book. Or a fantastic gift for this gift-giving season, the beautiful, lovely hardcover copy of the Law of Self-Defense Principles. This one's not free because it costs too much money for us to print up, but it's a lovely, lovely book, lovely gift, and it may well keep your loved one from spending the rest of their lives in a cage if they're compelled to defend themselves, their family, or their property from criminal predation. If you'd like to order this book, you can get it at lawofselfdefense.com/gethard. lawofselfdefense.com/gethard. And with that, I will just remind all of you that if you carry a gun, so you're hard to kill, that's why I carry a gun, so I'm hard to kill, so my family is hard to kill, then you also owe it to yourself and your family to make sure you know the law, so you're hard to convict. Until next time, I remain Attorney Andrew Branca from Law of Self-Defense. Stay safe.